Commissioner Womack, you just referred to the majority of people in the Kent County Correctional Facility are people of color. And that brings me to my next question, Chris, and that is, I've called you Chris for so long, I should call you prosecutor.
That's fine.
Okay.
We know each other long enough.
We've known each other many, like 25 years. But anyway, bail is a real problem. You know, bail is one of the major reasons, or lack thereof, for why people are in the Kent County Correctional Facility, why so many people of color are there, or so many people without resources, so many poor people. How are you able to help bring about a change in how bail is set? For one, Michigan Court Rule 6.106, I believe C, there's a presumption of a person getting a personal recognizance bond, but rarely do you see that. For the most part, you see people are getting monetary bills, and then they are not able to post them, and so then you see a large number of individuals just sitting in jail who've not been convicted of anything, awaiting trial. How can you help that?
Well, one of the things we are helping, I guess, in terms of that Representative LeGrand, I'm actually surprised he's not here, is a proposed series, and once again, going back to you, probably describe it a little bit better, but he's got a series of bail reform bills that are trying to work its way through the legislature that the Prosecuting Attorneys Association has supported. Now, a lot of what he's talking about in his bills are, quite frankly, what we do in Kent County. The prosecutor's office, we don't do anything with bail. I mean, we don't have, I think that's the kind of the misnomer. We all watch Law and Order, and they see the prosecutor get up and talk to the judge about what the bail should be. We don't do that in Kent County. We have nothing to do with it. We write the charges. We have a court services program, and they have a form, and they look at the seriousness of the charge, any drug history, any history of failure to appear. It's about 8 points, and you've seen them probably as much as I do, that they do, and the court services come up with the recommendation for the judge. PR bond, PR bond with supervision, no supervision, whatever it may be. So a lot of what Representative LeGrand is trying to do is also going statewide with that, because most of the places statewide don't have anything like that. They just, the judge essentially picks a number out of his head in terms of what it's going to be. But going back once again, our concern is A, safety of the community, what is the offense and what is it going to happen, and B, is the person going to show up? And I think that could be a lot of the issues where we have at least some bond issues, is because there's a history of not showing up, or they don't have a stable residence, or whatever it may be, and those are maybe areas that we could try and work on, and how do we solve those issues?
Well, here's a solution. Couldn't your prosecutors appear and actually advocate for a personal recognizance bond at those first appearances? Could you make that a policy where you would send someone and they would say, we've looked at this offense and we actually think it's appropriate to have a personal recognizance bond here? Because when you look at what happens to a person who is incarcerated, the first thing they lose is their job. And then when they don't have a job, they lose their housing, they lose almost everything. They lose any kind of vehicle, anything they're making payments on, just because they're sitting in jail and they can't make bail. You could affect the policy by making it a policy within your department where when you know a person is not a danger to the community, and you pretty much assess that, is it correct?
No, quite frankly, we don't. When I write a charge, we get a preliminary, what happened in that offense, and we have maybe a brief criminal history, but we don't do as an in-depth dig into what court services does. I mean, the court services have investigators specifically sent out to look at, any drug problems, any history of substance abuse. We have nothing like that when we issue a warrant. So we issue a warrant based on what the charges are, what happened in that report at that point in time. We don't get the history, not nearly as much as court services does.
The court services has been doing this now for about 2 years. And we've not seen, I'm talking about with the new system and the new model that they follow, and we've not seen a reduction in the number of people incarcerated because they can't make bail.
I think we've been doing the court service has been doing a lot longer than 2 years.
No, the new model that they use for scoring.
Mm-hmm.
Okay.
Yeah, I haven't seen the numbers. I don't know what the numbers are, but I think it's, part of it, maybe you have to give it more time because we don't know what the baseline was to know what it's going to be, how impactful it is. But in terms of as a prosecutor's office, We don't know that stuff. That's why they have court services, and that's what's presented to the judge, so that maybe a conversation you have with the judge. But in terms of us, we are not involved in that, and quite frankly, I don't have the bodies to send to every arraignment in Kent County, because you're talking about 61st, 63rd, 59th. We're scrambling just to cover the court proceedings that we have to be at, preliminary exams, pretrial conferences. I don't have the bodies to send. 34 attorneys is not enough.
Well, maybe you can't with the 34 attorneys, but you could make clear that it's a policy of this office that PR bonds should be issued where they're appropriate, and that this should become the norm and not the exception. Like in the federal system, there's a presumption that the U.S. attorney has to rebut. Okay, it's a rebuttable presumption, but the U.S. attorney has to rebut the presumption that a person is not entitled to a PR bond. And why are we not following that type of model?
Well, you already say the court rule. So if the judges aren't following the court rule, what am I going to weigh in and do? The judges have the court rule in front of them, and rebut the presumption. We don't have the information. That's what I'm saying. We don't have the information to weigh in on bond. So it would be very difficult for us to do that.
Then what can you suggest that your office could do to help solve this issue? Because you agree it's a problem, do you not?
It's an issue, definitely. And I think it's something we got to take a look at. If it's only been 2 years, as you're saying, in terms of what this system's put out and this new scoring system, let's give it some time, take a look at it, and sit down and study it. All we're doing now is talking about anecdotal type of things. I don't know what the numbers are, quite frankly.
Okay.